Your Honors. Can you hear me okay?
We can hear you. We can't see you.
Aha. That might be a blessing.
There you are. There you are. Okay. All right. Ms. Mogensen, you're up.
Good morning. I would like to reserve 5 minutes of rebuttal time, if I may. Andrea Mogensen on behalf of appellant Ian McCullough. We're here on our direct appeal of his criminal conviction for possession of child pornography. First issue that we've raised in the appeal is that we believe that it was ineffective assistance of counsel on the face of the record for trial counsel to have failed to challenge the affidavit supporting the search warrant. We feel that it fails under the authority of this court from Gazel versus State from 2020. Our principal complaints about the affidavit supporting search warrant is that the search warrant application characterized in general terms and in non-specific terms that there was possession of contraband but failed the specificity requirements, that the commission element failed because the applicant law enforcement officer alleged that there was discovery of child erotica, which is lawful nudity, and or child pornography, which was insufficient to suggest that there was commission of a crime because it needs to be contraband that's identified.
Ms. Mogensen, 9-year-old Arab pedo girl fucked by dad. New pedophilia, 8-year-old girl anal penetration. 5-year-old girl raped by dad, preteen child pornography, illegal PTHC, pedo. You're telling me that that's not specific enough for a neutral and detached magistrate to find reasonable grounds for belief that whoever is responsible for sending those videos is guilty of possessing child pornography?
I think that what a file is titled is an indicator of what may be in the file, but it does seem to me that someone should check what the contents of the file are as compared to relying on the titles of the file. Because what's prohibited, contraband in Florida, is specifically outlined in the statute in order to ascertain it's the image that's unlawful, not the words. So while I think that that's understandable and frankly quite disturbing, I don't think that's determinative of whether the items are contraband or not. It is noticeable to me that the affiant did not claim to have reviewed any of the images. They contended that someone else reviewed the images and identified them as child pornography, but we don't know who that person was and whether those images were compared to Florida law and what's prohibited here.
But we're not dealing here with evidence sufficient to convict or not. We're here with on the question of whether there was probable cause to believe. And this case, these images had hash values, did they not, that had been assigned by an organization whose purpose was to root out online child pornography, correct?
That is correct.
And and do we have any reason to doubt that this officer, could rely on those or knew what they meant? I mean, he reported that they had the hash values, correct? That's what he put in the affidavit.
Right. And what we're talking about is a national database that's supplied by law enforcement officers when law enforcement officers make a determination that they believe that a statute anywhere in this country may have been violated.
Well, I mean, the thing is like at some point we have to draw a line and say if someone has found this to be child pornography. I mean, if the officer, Gazel, the problem with Gazel is the officer said, oh, this was child pornography. And he did not provide any other description of what the items were. His training showed nothing involving child pornography. Here you got the descriptions placed on the files by whoever posted them themselves. And you've got an officer says these files have the hash values that are assigned to these files when, the world at large has determined that they're pornographic. Well, is that enough to create probable cause to believe?
I think the difficulty with the database is it's entirely full of data that falls under the Gazel problems. Some law enforcement officer somewhere has suggested that these images have been identified by that person as violating a statute in Maryland, New Mexico, Florida, Wisconsin, somewhere. And the issue that we're trying to raise is that determination is not properly made by law enforcement officers. At issuance of a search
Let me
warrant.
come back. Let's come back. Like in Gaisel.
Mhm.
Yeah, I mean, are you saying like in Gaisel, the fellow had not had any training in child pornography, right? It was all of his training was how to go through a computer and find stuff. I mean, it was technical stuff. Okay. But I mean, so if he had gone and had the training, are you saying, well, we can't rely on the trainer?
Well,
I mean, at some point, we're going to have to say there's enough accumulated knowledge that it at least creates probable cause to believe that evidence of a crime will be found. I mean, that's the test for crossing into a private area, correct?
I understand the point, but what the question becomes, that database has been is determined by law enforcement officers what they believe to be violative of some criminal statute somewhere.
Or what has been found to have been violated,
Right.
to have violated.
But there's no distinction. How are we to check? There's no one else is permitted in the database. How does the detached and neutral magistrate determine whether the images presented as supporting this particular search warrant to enter this particular home are indeed violative of some criminal statute in Florida?
I think though you might be suggesting an impossible standard. As I said, going back to Gaisel, if the fellow had training, how is a neutral magistrate to know whether the trainer knew what child pornography was? You can carry that on ad infinitum and decide there's never a possibility of probable cause.
Well, it would seem that the successful applicants have reviewed the images and described in general terms what the images contained, not the titles, not the hash values, and not relied on someone else's determination, but have described image 1 depicts a child appearing to be 5 to 7 years old and engaged in this particular activity. It seems that there needs to be something for the magistrate to rely on that is not a conclusory statement of a law enforcement officer, because that's what's required by Gaisel, and that's what's required by.
The law enforcement officer didn't really make conclusory statements. He made factual statements. These items carried hash values, meaning they had previously been found to be pornographic. This file has this title, and he set out what the title was. I mean, there you go. You're saying those things were not enough to create probable cause to believe that evidence of a crime would be found if they searched.
Unlike in Gaisel, Detective Ellis didn't just say, I reviewed the titles and they are indicative of child pornography. That would be analogous to Gaisel. That's not what we have here. We have the detective actually setting out the titles for the
Right.
magistrate to review.
But in appellant's view, the conclusory statement is that someone else reviewed the images and determined them to be violative of the statute, and that someone else's training experience is not enumerated in the affidavit. The database is filled by cases like Gaisel, where some law enforcement officer that may or may not have had the proper training have uploaded to the database as verified child pornography.
You're making a fairly conclusory statement there, that the database is filled with stuff that officers have put there, even though they didn't basically know what they were doing.
No, I'm saying the neutral and detached magistrate does not know that. Whether it's Ellis himself saying, I reviewed them and determined them to be child pornography, or unnamed officer that we don't know who they are saying it's been verified as child pornography, so now Ellis can say that to the magistrate, seems to me to be a distinction without a difference. That's the argument.
This database is, and it's not a brand new thing, and it's not an unknown thing. It's well-known, well-established database, is it not?
Well, it's a well-established database that is not subject to challenge. Only law enforcement officers can review what's in the database and add to it and subtract from it, and the magistrate doesn't have any experience in that, nor do those of us who are defending people who are accused of crimes. So it is a long-standing database, but I don't know that we can challenge that database. We're not permitted in it, which seems to me to be sort of frightening from a constitutional perspective, that we're relying on this data exclusively provided by law enforcement officers for probable cause to enter people's homes. And that's what the Fourth Amendment is intended to protect. I did want to talk
Let me
a little
approach
bit
it from
about,
a different point, if I might. And getting ready this morning, I went through my notes and I found a matter I hadn't recalled I was going to ask. My question concerns the Supreme Court of Florida's opinion in Steiger that came out in November that indicates an unpreserved claim for ineffective assistance of counsel ought not to be heard on direct appeal. On the status of this record, it would appear that this is the first time this has been raised and that your burden would be to show fundamental error. Is that correct?
I believe so. The Steiger opinion came out while this case was in the pipeline, after the filing of the initial brief, but before the filing of the answer brief. And while the state didn't raise the Steiger issue, and so therefore I didn't brief it, I did consider it. And I looked at the Steiger opinion, which I found to be a little bit, I'm not going to say confusing, but the Steiger court reaffirmed the standard for ineffective assistance to counsel on direct appeal as having to be apparent on the face of the record, et cetera, but also found in that case that the statute would not permit them to review in that case. So I looked
Well,
at
it makes it interesting because the word they use in there is unpreserved. Does that mean that trial counsel has to make a claim to the trial court? By the way, Judge, I was ineffective and I'd like you to rule on it in order for you to go back to the original standard. Because Steiger says an unpreserved claim, which usually means the trial court had an opportunity to rule on it before it arrives at our portal, so to speak. And so if it's an unpreserved claim, then we are to look at it in terms of fundamental error.
Well, actually, that's a very good point, because if it's an unpreserved claim, it does presuppose that it was actually raised. So I do think there's that distinction. And I also think, when I considered this case in particular, that because the Steiger opinion is so new, there isn't a lot of jurisprudence on what's fundamental error in the context of ineffective assistance of counsel. But it would seem if the standard for fundamental error is an error that reaches down into the validity of the conviction itself, because the guilty verdict could not have been obtained without the benefit of the error, that failure to bring a dispositive motion that would have eliminated all of the evidence upon which the appellant was convicted would be a fundamental error, because the state could not have proceeded had trial counsel not committed. If trial counsel had not committed this error, the state would not have been proceeded. That's the nature of a dispositive motion. So while
the motion could have been filed before trial or even at trial, could it not?
Right, and the failure to do so seems to me to be fundamental, although I did not find cases that specifically address that issue, presumably because although there have been opinions similar to Steiger, Steiger has is more recent and has come after cases that express the standard that there are circumstances where you can look at unpreserved error on direct appeal. So I do think there is fundamental if Steiger applies, but I do think there's a possibility that it does not, because the unpreserved error, as you stated, would presumptively have to have been raised. One of the other issues that I had raised on direct appeal and I thought was important to discuss is that it's the state's burden to provide proof, competent substantial evidence of each and every essential element of the offense charged, and that in this case, the state failed to produce any evidence or any suggestion that the images that they had submitted to the jury for conviction were of actual children, nor of what ages they were at. And because penal statutes are strictly construed according to their letter, it is their burden to provide that evidence. It's typically done by way of expert testimony, and the state failed to do that here. Because the statute requires that the child be an actual person and not a simulated person, it's the state's burden to do so and not the defense burden to raise the issue. But trial counsel did move for a judgment of acquittal on that basis, and it's our position that it was wrongfully denied pursuant to the Parker decision and State versus Robinette as outlined in our initial brief. I also think a judgment of acquittal was supported for failure to establish knowing possession. There's a double scienter requirement with possession of child pornography that you have to knowingly possess the items, and that you have to know that they're contraband images. And what the state's case suggested here is that a program ran in the background and continuously downloaded over days images. And while they provided ample evidence of the dates and times that the downloading was occurring and the dates and times that they found what they call artifacts, which would be files and computer indications that a particular user was sitting at the computer, what they failed to establish is that that user would be have knowing possession of what was running in the background and what was occurring in the background.
Well, didn't somebody type into the search terms snuff, bestiality, pedo mom, mommy and daddy, PTHC?
Yes. And what would seem to
That
be
seems pretty knowing.
that what would seem to be, well, it is a shared computer. It was established that it was a shared computer in a shared space in a home where more than one person lived.
Not so much. Wasn't the computer was in his room, right? And wasn't it password protected? And his
Yes.
his housemate only could use it under very limited circumstances, I think, but he retained all the passwords.
Well, Detective Clay and Detective Ellis were both able to access the computer without the use of a password. The record suggested that when the computer went to sleep, all you needed to do was wiggle the mouse or tap the space bar. And that's in fact how law enforcement officers awoke the computer when they served the search warrant. They either wiggled the mouse or tapped the space bar and did not use the password to get in. And it also showed that the computer had been inactive for over an hour and that the images were continuing to download, but there was no other activity. So it seems the necessary logical connection was not made between the input of that search data. Whoever put in that search data certainly was seeking possession of such contraband images, and you could circumstantially presume that that person had knowing possession and was the person looking at them, but they failed to put the appellant in this case at the computer at the time that the search terms were entered, or when the activity seeking the contraband images were was conducted, or the viewing. They put the appellant at the computer several times, but never at the operative times to support the conclusion for each of the 40 images charged. They would have to do so for each image as compared to just in general. This is ownership and use does not equal knowing possession of each and every one of those 40 images. So when they put on the proofs of each image, it would seem to be necessary for the logical conclusion to apply for a serious crime such as this, knowing possession of that particular image, some activity of seeking that image or viewing that image, suggesting that Mr. McCullough specifically knowingly possessed those images and knew that they were contraband. I did want to spend some time on our last issue because I think it's a very important issue that needs to be addressed, is the closing arguments in this case. I don't think that my esteemed colleague really disputes that the two wild theories, outlandish theories, conspiracy theories, the denigration of the defense was improper. The question is whether it's fundamental error because it was not objected to or preserved. But we submit that the cumulative error of prosecutorial misconduct must be looked at. And I've raised two issues: the state's use of the suggestion to the jury that the only person who has interest, or the primary person who has interest in the outcome of a case as an accused, should be considered in the credibility analysis of that individual as a witness, is contrary to Florida Standard Jury Instruction 2.1, where the jury is instructed you should not consider the fact that the defendant is charged as evidence. And
But doesn't the trial court also instruct the jury to ask itself, did the witness have some interest in how the case should be decided?
Yes.
And then further instructed the jury, you should apply the same rules to the defendant because the defendant's offered himself as a witness?
Yes.
Why isn't that line of questioning or line of argument completely consistent with that instruction?
Because if we are going to treat the defendant as any other witness and then argue that they're the only person charged, we are not treating the defendant as any other witness. We're asking the jury to consider the state's decision, charging decision, in the credibility analysis, and that is denigrating the constitutional right to be present to confront your accusers and to put on a defense. That means that every criminal defendant that sits in the defense chair it can be suggested that their credibility is at issue because they've been accused. And while a jury may think that, to permit a government officer who's got the power of the government behind them to instruct the jury to consider that seems to be as offensive as to instruct the jury that the fact the person remains silent should be used against them. My opponent argues that there is a logical connection, and there is, and that's what makes it so dangerous. There's a logical connection between someone remaining silent and a presumption of guilt, because one could argue logically that if you were innocent, you would protest your innocence. But that's not permitted because it denigrates the constitutional right. And it seems that to argue that because the defendant is always present, that they can tailor their testimony, and because they're charged, they are biased, that denigrates those rights and the presumption of innocence. Because it's
you're at your rebuttal time. Just giving you
It's because it's literally the fact that there's an accusation that's being asked to be used in the credibility analysis, and that seems to offend constitutional principles. Thank you.
Thank you. Ms. Richards?
Good morning, Your Honors, Counsel. To jump right into this, it's Cynthia Richards representing the state from the Office of the Attorney General. I'd like to start with the issue 1 because there was quite a lot said, although Judge Rothstein, I think you made my argument for me very well. Thank you. You're exactly right. And let me read specifically quote from the warrant when we're discussing about whether someone should check what is in file. If you read the testimony of Detective Clay during the trial, he went on and on and on about being part of a 4-person team. And when they receive these alerts from the database, they review them. So there is that extra layer. And it says right here in the warrant that your affiant made a total of 11 direct connections with suspect IP address and attempts to obtain files that the suspect IP was showing to be in possession of and that had hash values previously identified. He goes on to say all of the files contained were in fact child pornography. You're correct. He outlined the titles of these files, and he made a distinction even in the warrant that there was 101 and in other places more than 1,000 different files. And even in the warrant, he made a distinction of the files that he was able, the alert came through that were on the appellant's IP address on his computer, and the files that were actually actively being shared by the appellant's computer to the sheriff's office computer. And that's a big distinction. It wasn't just random. It possibly could be on here. He was saying this IP address is sharing these specific videos with our computer right now. And he did put in everything needed that a reasonable judge could find probable cause that a crime was being committed at appellant's address on appellant's computer, which was registered in his name. But there was testimony by Detective Clay that the team reviews the alerts. So it's not just they get an alert and pass it on and say, look, we found, somebody told us from this database that this file with this hash value, there was more to that.
Testimony at trial. I mean, we're talking about, it has to be on the 4 corners of the application, correct? Magistrate who issues the warrant doesn't have the benefit of the testimony of trial.
Correct. But as I said, the distinction was in the 4 corners itself, along with his training, along with the hash values, all of which, case law specifically says it's like a fingerprint. These hash values in this database are not random. They're not somebody's opinion in some state, oh, this looks like child pornography to me. This is an identifiable image based on a date. It's quantifiable and it's almost 100%. It's a fingerprint. And if you look at the US v. McNevich, where is this? US v. Riddick, specifically out of the 5th Circuit. These are all, the case law supports the hash values. But as I said, he went an extra step and went, not only do we have hits and alerts from the database on files with specific hashtags, we have the appellant's computer actively sharing files to the sheriff's office computer. And that's not something that runs in the background. To share a file, you have to click OK, click send. It's not the IP address, and the random running of a background program does not seek out law enforcement computers or anybody's computer to share files with. That is actively done by the user of the computer. So I would suggest that there is absolutely, within the four corners of the affidavit, more than enough to give a judge probable cause for an affidavit. And as far as the unpreserved claim, while Steiger might not have been addressed, there are other cases like McComb v. State from this court, also quoting Forget v. State from this court, holding that the ineffectiveness as counsel can be addressed on direct appeal only when the ineffectiveness is obvious on the face of the appellate record, the prejudice caused by the conduct is indisputable, and a tactical explanation for the conduct is inconceivable. None of those things apply to the four corners of this affidavit. Moving on to the judgment of acquittal arguments. Appellate makes the claim in issue 2 that the state did not present a prima facie case that they were in fact children. As Judge Rothstein pointed out, not only is the titles of the videos a good indication, but in the testimony itself, as I said, Detective Clay said that these images were reviewed by them. There was an agreement between the state and the defense not to play the entirety of all 40 counts of the child pornography to the jury. One of the videos on its own was over 3 hours in length. So to say they did not prove that they were children after agreeing to only use a snippet is a bit disingenuous. And if you look at
Ms. Richards,
Yes,
despite the limited amount that was played, all of it was sent back to the jury, right? So if there was a question, the jury could review the entire video?
that is correct, Your Honor. And in fact, the judge made a specific point with the 3-hour video in itself that he had the state pull up, because whatever snippet was played apparently was not graphic enough, and had the state pull up a still that the judge personally reviewed and said, no, this is most definitely is what it claims to be. But you're correct. All of it was in evidence and sent back with the jury. And it is a jury decision in this case. If you look at US v. Fairley out of the Sixth Circuit, question of whether photographs depict actual children is a question of fact, not law, and appropriate for the trier of fact, or the jury in this case. So whether they were children or not is a jury issue, and the JOA, denial of the JOA, was appropriate in this case. And whether or not the appellant knowingly shared, as I said previously, and Detective Clay testified too, it wasn't a background program running, not only, it was active file sharing. And because the appellant chose to testify in his own behalf, the jury also got to hear his explanation in the narrative that he was set up by 2 police officers who, instructed him on how to pirate blockbuster movies, and then apparently another law enforcement alleged that showed up as a Frontier person that had to replace a battery in his router. This was appellant's reasoning and how he did not know. However, what's also in the record is the letter he wrote to judge when he admitted saying, oh, and I saw those pornographic videos, I was sick to my stomach, I was horrified. Defendant himself admits to seeing them. And as I said, it's not just, Detective Clay went on in great detail about how file sharing works, how it's not random. Files don't jump from one computer to the other without being actively shared. And he was at home alone when the warrant was issued. There was testimony from his roommate that previously she was allowed to use his computer only when he logged on for her. No one ever had his password. She did not have his password. His room, his door to his bedroom, by appellant's own testimony, was locked. And there was nobody home at the time. And if you look at first DCA in Bussell v. State, where contraband is found on the premises in joint possession, even though it wasn't, he did have a roommate, but she was not home. Knowledge of the contraband can be established with actual knowledge or circumstantial evidence from which a jury could infer guilt. It's a jury call. Jackson v. State from this court in 2008, inference of knowledge and dominion and control can be demonstrated by showing that the contraband is located in or about other personal property which is shown to be owned or controlled by the defendant. It was on his computer, in his name, his IP address, registered to him at his house, in his locked bedroom, where he was alone. That is sufficient for the denial of the JOA in this issue, Your Honor. And moving on to the final issue about prosecutorial misconduct. Once again, Judge, I agree with you that the prosecutor's isolated comment, it was not a nonstop tirade against the appellant. It was isolated comments on the rebuttal argument and also in direct response to the defense argument that there was a magical week that the state was claiming in which the defendant downloaded and shared all of these things. The appellant chose to make himself a witness in this case. And the comments made by the state in their rebuttal closing argument was absolutely fair comment on appellant's testimony. From reading the record, we don't have to go through all of the facts again, but as I said, the appellant stating that he was set up by the police to instruct him on how to commit piracy, you know, it is outlandish. It absolutely is outlandish, and that was a fair comment. If you look at Randolph v. State, the fact that there was no objection made at the time waives that issue to be in front of this court at this time. So the court determined that failing to raise a contemporaneous objection with an improper closing waives any claim concerning the comments for appellate review. It also cannot be fundamental error because at this point that 2 or 3 comments in rebuttal closing that the state made cannot in any stretch of the imagination be said to be the only deciding factor that the jury would find appellant guilty in this case. I would think the hours of pornographic video that were in evidence would absolutely belie the fact that a comment by the prosecutor would reach down and vitiate the entire trial, and that the defendant could not possibly have been found guilty without the prosecutor's closing comment. So unless there's any question from your honors, I'm going to rest on my brief in this case. I thank you for your time.
Thank you, Ms. Richards. Okay, Ms. Mogensen.
With regard to the argument made with sharing with the sheriff's office, I would ask the court to review the record on that issue. The argument as advanced is at odds with the evidence and seems to reflect a misunderstanding of how shareware works. When the files, what the testimony was, as I recall it, and as I know it to be, is that when the files are finally downloaded, they are downloaded into a shared file with other users. It is not like sending an email, that the shareware grabs pieces of files from all sorts of other users, and once it lands in the shareware download file, it is available to other users for that same purpose. So it is not, the evidence does not suggest like sending an email or sending a link or an actively in the moment sending. The files become shared when they're fully downloaded for a particular user. So the suggestion that because the sheriff's office was receiving them on a particular day suggests that the person who was sending them was there is inaccurate factually on the record. I do think that the argument that that Detective Clay reviewed the images does not shore up the deficiency that no one testified that they were actual children as compared to computer-generated images. Detective Clay is a competent witness to testify to that sort of fact because the images can be examined to see if they're computer-generated in the metadata, but nobody did that. And nobody testified that to the jury. And it is a fact question for the jury, but the determination needs to rest upon competent substantial evidence presented to the jury by the state, not presented to the state, but to the judge by the state, presented to the jury by the state. And there was no expert testimony. These images have been identified to be the Katie series, and we've identified that as a human being, etc., nor having the computer expert who was actually present at trial testify. And we've evaluated these images and determined them to be actual video footage and not computer generated, etc. It is an element of the offense. The proof is required and the state failed to do so. And for that reason, a judgment of acquittal should have been entered. With regard to the prosecutorial misconduct, it was not a single comment, it was multiple comments. And the state agreed in their written briefs that the comments were inappropriate, but argue here today that they were fair game. I would suggest that their written response is more accurate than the law supports, that no matter what, under no conditions, as professionals, as a matter of professionalism, we don't denigrate our party opponents and we don't denigrate other attorneys and their presentations. The proper function of closing argument is to assist the jury in drawing inferences from the facts. And I did put in my brief the Ambrosio versus State 1999 case where it's discussed, Borden Inc. versus Young, where Judge Schwartz pointed out that these types of defects, and especially in a case where the state has such a great advantage because of the horrifying nature of the images presented to the jury. Just presenting the images in their existence is insufficient to support a conviction, but for a jury to review those images, the state is way ahead of the game, because obviously a jury seeing that would naturally want to punish someone for having those images. It's especially unnecessary for the state in the final rebuttal to engage in improper argument, such as denigrating the defense or suggesting that the defendant for having been charged should be disbelieved. And in that Schwartz rule, it's discussed that it's not just the party in the particular case that's injured by prosecutorial misconduct or by improper closing argument specifically, because that was a civil case, that it's justice that's denigrated. And it was suggested as the Schwartz rule that the transgressor should be smited with a new trial for the transgression because it offends not just the party, but professionalism and justice itself. And in a case where there are horrific images and there is a tenuous and unproven connection between the person who is charged and the images, as I suggested in my JOA arguments, the connections the state failed to make as to knowing possession and as to actual children, for the state to rely on improper argument at the end when there is no rebuttal should result in a new trial. And I would ask that the court consider that type of misconduct not be condoned in any context, but particularly in a context when there is liberty at stake. So unless the court has any questions for me, that would be what I would submit in rebuttal to the appellee's argument.
Ms. Mogensen, thank both of you very much. In order to leave our virtual courtroom, you need to click the leave button on your Zoom screen, very succinctly labeled, and you'll disappear into the ether and we'll call the next case.
Thank you.
Thanks.